What begins as a routine court hearing quickly turns into a tense and dramatic showdown when Judge Perkins faces a defendant who refuses to recognize the court's authority. Java Grayson Bay, claiming to be a sovereign citizen, repeatedly argues that he does not consent to the proceedings and believes the court has no jurisdiction over him. As the hearing progresses, the courtroom atmosphere grows increasingly intense. Instead of cooperating, the defendant challenges nearly every statement made by the judge, creating confusion and constant interruptions. At one point, he even threatens to file a lawsuit against the judge if the case is not dismissed, shocking everyone present. The prosecutor expresses frustration with the ongoing disruptions, while Judge Perkins remains calm but firm, making it clear that personal beliefs cannot override the law. Despite repeated objections and unusual legal claims, the judge decides the case will move forward and takes decisive action to restore order. The hearing ultimately leads to a major decision, resetting the case for an in-person jury trial, ensuring that all evidence and arguments will be properly reviewed. This intense courtroom exchange becomes a powerful example of how the legal system handles challenges to its authority and maintains control under pressure.
Good morning to you, sir.
Your Honor, I'm going to represent myself in this matter. And for the record, my name is Grayson Bay.
All right. City of Detroit versus Javar Grayson Bay. Your offer, sir, is a $240 fine, failure to display, and a seatbelt ticket. You pay those, we'll close the other matters out. That will abstract to the Secretary of State. And then the seatbelt ticket is $65. So $240, $65. We'll close the matters. We'll close the matters out. That'll be a failure to display. It will abstract, but it won't carry any points. And today is the date and time set for a trial.
Your Honor, today was supposed to be set for trial, and I don't consent to any of this.
It's set for trial. I just gave you your offer so that you can you go in? Okay, there. I just gave you your offer so you could.
I'm not accepting that. I won't accept that offer.
Mr. Corporal Ambrose, can you put your appearance on the record, please?
Good morning, Corporal Brian Ambrose. Detroit Police Department, Badge 415.
Good morning to you. Okay, let's go. Are you ready to proceed, Corporal Ambrose?
Yeah.
Your Honor, I would object to holding this trial. I believe he stated that he's a different person. We have a ticket for a Mr. Javar Grayson. Grayson Bay is an entirely different person. We don't have jurisdiction over. We don't have a case over. I would object to holding that trial.
I'm going to deny the objection. He just said he's Grayson Bay. He just I don't think he's objecting to the fact.
I object to that, Your Honor. I'm objecting, and I also questioning jurisdiction.
Well, I'm denying your motion about jurisdiction, sir. The court has jurisdiction over you, so let's. Are you ready to proceed, Mr. Grayson Bay?
No, I'm not. I object to anything that you call yourself doing. Also, I'd like to add that I sent this Brian and brochure. I sent him a COL. It's a cut-off law form. I warned him about this situation. This process is also in Wayne County. He's being sued. We can continue this all day. I also will add you to the case if you want to continue this. This needs to be dismissed today. And I will see Brian Ambrose in 3 weeks in Wayne County.
All right. Well, let's go ahead and proceed because it's not going to be dismissed today. Okay.
Well,
so you can do what you want to do over in circuit court. Then have your way. That is your right. I don't know how you're proceeding in circuit court when you feel that this court doesn't even have jurisdiction over you. So let's go ahead and proceed. Corporal Ambrose, you want to speak with you want to speak with them before we proceed, Ms. Snyder?
Yes, Your Honor, and I do think we just need to clear up on the record that Your Honor has denied my motion to not have this matter heard today based on this defendant saying he is not the defendant before us. And also that defendant has agreed that he is not the defendant before us, but Your Honor is telling us to still do this trial. I need to make sure that's clear on the record.
Yeah, I don't think that he's denying that he's not Javar Grayson Bay. Are you denying that you're not Javar Grayson Bay, sir?
I am the living person, Grayson Bay, in living form.
However he wants to articulate it, we'll let him articulate that. He's Grayson Bay. He's Javar Grayson Bay. His mom gave him that name. I don't think that's any dispute. Okay, so
that name has a social security card attached to it. It also has.
I think it's going to be pretty quick, Ms. Snyder. I'll put you in a breakout room with Corporal Ambrose and put it that way. It is just an expired plate, a seatbelt ticket, no proof of insurance. What is this other thing? Refuse to exhibit license and a false information ID. So just join the breakout room, have a conversation with Corporal Ambrose, and then we'll just hear it. And if he has a right to remain silent, he says he doesn't want to be represented by a lawyer, and you can just put your case on the record, and I'll have to make a decision based on that.
Has advised me to file an interlocutory appeal, Your Honor.
An interlocutory appeal on my motion, on your motion?
Yes, Your Honor.
Okay.
Or I suppose time to brief the issue, maybe on this record, or I'd leave in Your Honor's discretion.
Let's see does that interlocutory appeal, if that is
I'm sorry, Your Honor. Are we back on the record for Grayson?
Yeah, let's go back on the record with Mr. Javar Grayson Bay. Now, there's that interlocutory appeal. I mean, I have to proceed. I mean, I got the discretion of whether I want to allow you to do that or not, or just proceed, and you can file your appeal. Correct? Give me the law on that. You're muted, Miss. You're muted, Miss Snyder.
I'm sorry, Your Honor. My supervisor is talking to me over the wall, so it's hard to hear two people at once.
Okay.
The court rule is, I think she might be coming back. It's MCR 7.205.
7.205, application for leave to appeal, and you said what was the citation? What were the other?
7.212, but that's just saying the format for briefs.
I have 7.205 as application for leave to appeal. Appeals to circuit court. 7.105. If the order appealed is interlocutory, setting forth facts showing how the appellant would suffer substantial harm by awaiting final judgment before taking an appeal.
We believe that the substantial harm that the people would suffer would be the defendant has already stated he's filing numerous lawsuits against the court, against the parties, against the officer. We believe we'd be giving him a golden parachute. It's just one more issue to add to his level of appeals. This is one issue that needs to be clarified. Of course, he will be found, I believe, through fingerprints to be either the person given that ticket or Javar Grayson, the person given the ticket, will be given a capias warrant and we can move on. But I do believe that this issue needs to be handled before we make a further record. I have a duty to mitigate the city's damages. And I believe that's what we're doing and what I was advised to do by my supervisor.
But how would the city be harmed at all if we proceed? What would be any harm for the city? Especially if you acknowledge the fact that you think that by fingerprints that would be Mr. Javar Grayson.
But Your Honor, what we think and what we can prove as a matter of the record and as the court of law is different. I do understand. I believe he's being frivolous. I think he is wasting the court's time. But I do think that as lawyers, as a court of law who do have to face appellate issues, this is something that we need to clear up on the record and have a clear record, such as a chain of custody of who Mr. Grayson is. I don't think it would take that long. Or we could solve this today with giving Javar Grayson a capious warrant and let Bay, whoever he may be, go on about his business. Either or. But I do think that having this trial over both of our objections is not the correct answer.
I just don't feel. I just don't feel.
You can't send
one. I don't see any harm in proceeding. He's already indicated that he is Javar Grayson, except he wants to be acknowledged as Javar Grayson Bay, or he's the living. I don't know how he termed it. Person of Javar Grayson Bay. I don't think that, as a matter of fact, when Corporal Ambrose came in the room and introduced himself, I saw Mr. Grayson Bay sort of kind of had a look on his face. And to me, I took that look as he knows Corporal Ambrose. And there's no question. I haven't asked Corporal Ambrose if this is the person that he pulled over, but I'll definitely let you ask Corporal Ambrose that. But I don't think that there is any sort of identity issue here. I think the issue comes into something that we've seen probably, I don't know how many times, and I'm sure we're going to see it more in the future. And I agree that those things are frivolous and they do not apply. So I don't see anywhere where we can't.
The courtroom was tense from the very beginning. Judge Perkins faced a defendant unlike any other, a man named Javar Grayson Bay, a self-proclaimed sovereign citizen who refused to acknowledge the authority of the court. From the moment proceedings began, Grayson Bay made it clear that he would not comply with standard legal expectations. He openly stated that he did not consent to being prosecuted and argued that the court had no jurisdiction over him. This refusal set the stage for a confrontation that would test both patience and procedure. As the hearing continued, it quickly became apparent that this would not be a typical legal exchange. Grayson Bay repeatedly challenged the court, questioning every instruction and every assertion made by the judge. He insisted that the proceedings were illegitimate, claiming that personal consent was necessary for the court to have any power over him. His arguments were a mix of legal jargon, misinterpretations of law, and personal theories, all aimed at creating confusion and delay. The atmosphere in the courtroom became charged as the judge calmly tried to explain the legal reality. The law applies to everyone, regardless of personal belief. The tension escalated when Grayson Bay threatened to sue the judge personally if the case was not dismissed. This bold and unusual move shocked the courtroom, demonstrating the extreme lengths to which he would go to resist authority. The prosecutor, Ms. Snyder, quickly expressed frustration with these tactics, pointing out that Grayson Bay had a history of filing lawsuits and that his disruptive behavior could create serious complications for the city. She requested an interlocutory appeal to clarify identity issues and ensure that the case could proceed without confusion, emphasizing the importance of maintaining order and accountability. Despite these repeated challenges, Judge Perkins remained firm. He understood that allowing frivolous arguments or threats to dictate the course of proceedings would undermine the justice system. He patiently, yet decisively, addressed each claim, making it clear that personal theories and misunderstandings of the law cannot override established legal authority. The courtroom became a test of endurance, as the judge balanced the need to maintain order with the responsibility to allow the defendant to voice his arguments. Grayson Bay continued to assert that documents he had supposedly filed were not being recognized by the court. He claimed that his identity and actions were being misrepresented and refused to cooperate with the standard procedures. Every clarification from the judge was met with further objections, creating an ongoing cycle of argument and resistance. The prosecutor attempted to intervene multiple times, highlighting the practical consequences of these delays and emphasizing the importance of moving the case forward. The courtroom dynamic was now less about the facts of the case and more about the struggle between individual belief and the authority of the legal system. After considerable back and forth, it became clear that a resolution could not be reached within the standard hearing format. The judge recognized that in order to ensure fairness, proper review of all documentation, and accountability for both sides, the case would need to be reset as an in-person jury trial. Specific dates were established for motions, responses, and the pre-trial meeting. Even in the face of repeated confusion and objections from Grayson Bay, the judge maintained control, making sure that the legal process would proceed without being derailed by personal claims or misunderstandings. Throughout the hearing, the courtroom became a powerful stage for observing human behavior under pressure. Grayson Bay's arguments, while disruptive, revealed a deep misunderstanding of legal authority and a belief in his own ability to circumvent the law. The judge's measured, methodical responses highlighted the importance of patience, procedure, and adherence to legal standards in maintaining order. The interactions were not just a legal exercise, they were a study in conflict, persuasion, and the limits of personal belief in the face of institutional authority. What makes this hearing particularly remarkable is the contrast between chaos and control. Grayson Bay's persistent resistance and refusal to recognize the court created tension and frustration, yet it also underscored the resilience of the judicial system. Judge Perkins' calm, deliberate handling of the situation demonstrated how law and procedure function to protect fairness and uphold authority, even when faced with aggressive defiance. The hearing serves as a real-world example of how courts manage individuals who reject legal norms while ensuring that justice is neither rushed nor compromised. As the hearing progressed, every moment added to the intensity. Grayson Bay's insistence on the invalidity of the proceedings, his claims about documents, and his threats against the court revealed a mindset fully committed to challenging authority. Yet each time he attempted to assert control, the judge methodically reminded him, and the audience, that the law is not dictated by personal belief. Authority, procedure, and established legal standards prevail, and they guide the courtroom toward order and resolution. By the time the hearing concluded, it was clear that the legal system had successfully navigated a complex and unusual challenge. The decision to move forward with an in-person jury trial ensured that both sides would have an opportunity to present their arguments fully and fairly. It also reinforced the principle that, regardless of one's beliefs or claims, the law applies equally to everyone. The courtroom confrontation between Grayson Bay and Judge Perkins was not just a legal proceeding, it was a demonstration of the principles of justice in action, showing how authority, patience, and procedure intersect to maintain order in the face of chaos. This case leaves a lasting impression on anyone observing the judicial process. The exchanges between Grayson Bay and the court highlight the difficulties courts face when dealing with individuals who attempt to resist authority through unconventional beliefs and legal misunderstandings. At the same time, they show the effectiveness of a calm, structured, and principled approach to maintaining control and ensuring justice. The hearing is a reminder that law is not negotiable, and that even the most confident and disruptive arguments cannot override the rule of law. From start to finish, the courtroom confrontation is a compelling study in tension, strategy, and human behavior. Every objection, every challenge, and every moment of confusion underscores the resilience of the legal system and the importance of procedure, fairness, and authority. Judge Perkins' handling of Grayson Bay demonstrates the skill required to maintain order and ensure justice is served, while the defendant's persistent defiance provides a vivid example of what happens when personal belief clashes with established law. In the end, the hearing between Grayson Bay and Judge Perkins serves as more than just a courtroom story. It is a lesson in authority, persistence, and the power of the legal system. It illustrates how courts maintain fairness and control, how judges navigate extreme challenges, and how the law ultimately prevails, even when confronted with defiance, confusion, and unconventional tactics. This is a courtroom showdown that captivates, educates, and reminds us why the principles of law and procedure exist to ensure justice, order, and accountability, no matter the circumstances.
Unless Corporal Ambrose says that to you and through you that this is not, I don't recognize this person that's here, and was this not the person that, or even if there was I would even allow Mr. Grayson Bay to put on a identity defense and say, that wasn't me. He did, that wasn't the defense. I don't know what his defense is going to be.
Your Honor, may I?
No, you can't. No, you can't. No. When I ask you to, when I want you to speak,
no
I'll allow
problem.
you to speak. I'm going to give you that opportunity.
No problem.
So to settle this matter about your objection, it's like if the court rules bound me not to proceed because you wanted an interlocutory appeal, then that would be the court rules would bind me to do so. But I don't know of a court rule that's going to bind me not to appeal. And I just don't see in what harm it will be to any other parties, the defense or the city, by us proceeding in this fashion. I understand he's got cases over in circuit court. He may have cases over in federal court. I don't know. But here again, we're here. The parties are present, and I'm satisfied at least that that's the Mr. Javar Grayson Bay, that we have the right person here in court today. So I'll let you make a last minute record, Ms. Schneider.
Can I just have one? My supervisor walked away. Can I have 1 second to go talk to her?
Yes. Now you can. Let's see if you want to. If Mr. Grayson has anything, I'm gonna allow him an opportunity to speak so you can hear what he has to say. Go ahead, Mr. Grayson Bay.
Your Honor, I sent you a declaration of notice stating who I am and the fraud, Javar Grayson. I sent you the paperwork. This was over 3 or 4 months ago. I'm pretty sure you have plenty of time to read and understand the situation. And that, like I said, again, that is my declaration of notice. You should have that in the file.
Anything further?
And I object to this. And again, your court system has no jurisdiction over it. Give me a point to a court rule or put your legal objection on the record. What is your objection? My objection is jurisdiction.
Okay, I deny that objection. All right. Go ahead, Ms. Snyder. We'll pass the matter. We'll allow you to speak with your supervisor. All right. Let's go back on the record with Mr. Grayson Bay. Are you there, Mr. Grayson Bay?
Yes, I am.
What I will do, listen, Ms. Snyder, let's go back on the record with Ms. Grayson. What I will do is I will pass this matter and I will reset this trial date for an in-person, because I think this is one that needs to be in person. We can't, it's been some stuff that Mr. Grayson Bay has said that he has filed with this court. He says he sent me some stuff. I don't have that in front of me. There's it in the file. And this one seems like it's going to necessitate some, it's going to necessitate a trial and I think that this one is best to be done in person. So what I will do is I will reset this trial date. That will give me an opportunity, one, to get the documents that, if they exist, that Mr. Grayson Bay has said that he has filed with this court. And then two, that'll have both of the parties here in person. All right, so I'm going to reset this matter for a January 9th in-person trial date. Now that is going to do. Now let me ask you this, sir. You understand you have a right to a trial by jury, correct? Mr. Grayson Bay?
I'm just challenging jurisdiction. Also, for the record, I sent Detroit Police Department 12th Precinct a declaration of notice. I also sent them a COL, which is a color of law.
Listen, Mr. Grayson Bay. Listen, Mr. Grayson Bay. I don't care about that stuff. All I care about is what's here before me right now.
Okay. Did you get the declaration of notice?
I don't. If I did, it's not in the file. I'm not going to say I didn't.
Okay, I'll send you another copy.
Let's make this a jury trial too.
I send you a copy. No, we're not. It's not a jury trial.
No, it is a
situation in your hands. No jury trial. You have a situation in your hands.
Room with Mr. Grayson.
No. It's not going to be a breakout room with him. Let's give him a jury trial date.
Oh, jury trial.
Yes. Let's just go ahead and he's not running this show.
I have Judge Carter.
Okay.
Do you have somebody like you want to assign to this case?
Not necessarily. I mean, anybody can, I'm sure, handle it.
Okay, that's fine. Thank you, Judge.
Yeah, let's get it.
If Miss, I'm not talking to you. I'm talking. Let's go off the record. Miss Harris, do you want the case of the Gomez Lopez?
No, thank you, Your Honor.
Okay.
I can't hear no more.
No, it's not. We're not talking about your case. We're off the record with your case. We get a jury trial date. Let a jury of his peers make the determination.
And I think we'll clean up the record issue within the person.
Judge, let me know when you're ready for the date.
All right, let's get a jury trial date. Tuesday, December the 5th, jury trial.
Don't get it.
We'll not schedule anything else on that day.
Okay.
Tuesday, December the 5th, 9 a.m. we will do. As far as motions are concerned, I'm going to set some motion dates. So, what was that comment, sir? Mr. Grayson Bay?
Yes, sir. What's going on?
Was that comment?
No comment. Listening. Let's go.
All right. Let's set a motion date for November the 10th. That's when Mr. Grayson.
That's Veterans Day, sir.
Stay good. Let's set motion due. Well, the motion will be due by November. Motions due by November the 9th. That's for both parties. The responses to the motions will be by November the 17th, and we will set a final pretrial date a day before on December the 4th, 2023. So technically, you'll have a court date that can be, it could be on Zoom for the final pretrial date of December 4th. If there hasn't any resolution, I'll give my ruling on the motions on that day. And then we'll set the jury trial date for December the 5th, 2023 at 9 a.m. All right? You got that, Mr. Grayson Bay?